something about how taking the developer out of the equation.
A section in the Land Acquisition Act 1960 which allows the government to acquire based on social and economic benefit. Okay?
Very wide.
Very wide.
Yep.
But really, in my own experience for years, this particular purpose has not been exercised. It's always for infrastructure and also infrastructure and transport. I myself have been involved for 8 years as the intervener valuer who goes to court for the challenges against WCE. So now, if we know exactly that the concern is there, now it comes to the next stage. Okay, before any such redevelopment has to be done, okay, perhaps there are studies to be done. We have economic and social study, impact study, which also are being done for me when I was actually opening up hypermarkets last time. We need to determine, whether it benefits. We had to engage universities and professionals to do the studies. From there, they will actually decide. Okay, there is a need, and it will not impact on the papas and mamas shops. So basically, this is where we are looking at the social impact of the community. So we're looking at protecting the interest of the owners, tenants, and those affected, interested parties.
So a whole bunch of professionals will be involved before the developers even come in. Having surveyors being the intermediary, surveyors leading a whole bunch of professionals. Your view?
Actually, once we talk about land development, the land is very crucial and very important. One of those property experts in the United Kingdom, Professor David Adam from Glasgow University, has mentioned that without land, no development will take place. So you're talking about building. Tak ada lagi bangunan di atas langit sekarang ni, yang ada di bawah di tanah. So section 5. But how could we make sure that the land is available in the market for the sake of development? We have to engage the landowners, the planners.
Land is actually a state matter. Everything that we have, everything that we get land is actually a state matter. It comes from the government itself. So when the government says that we have no land, I think that's not correct because you own all the land. So it doesn't make sense if they say don't have land. Then there's the second part. At the end of the day, surveyors on our side, we are actually the oldest profession in the world. We are actually the oldest. Profession because you want to know why at the end of the day, we are actually the land surveyors who actually come in to measure the land, to determine the size of the land, so that you can be issued a title.
Therefore,
land without a title, you cannot do anything whatsoever.
Agreed.
Then the title comes up, you say leasehold or freehold. Then after that, you got to say the size of the land. Then you got your express condition, and you got your restriction and interest to say what you can do on the land itself. So that is a very important document. And that must be identified. And then they see done by the land surveyors itself. And then after that, all the other QS, and then after that, the valuers, the property managers, the estate agents, all come into play subsequently. I just want you to understand the narrative of how it works. Property management aspect. Buildings don't go old or dilapidated overnight, It's not magic. You don't sleep tonight, tomorrow you wake up, then the building, going to collapse already. There's no such thing. You must do active property management. You must do planned preventive maintenance. There must be a law to say that, okay, we need an independent professional property person to come and manage that building. And there must be also an act. You know what's the problem at the end of the day? It's not to say we lack professionals or we lack consultants to manage the building. It's the collection of the maintenance charge. People don't pay. When you don't pay, right, you got no money. How to develop, how to manage, how to maintain. No magic.
They all have a code of conduct. They are licensed under a certain body. There's a certain way they have to do a certain way. How should we treat the disagreeing minority?
But of course, property development is an assembly process. It will involve many parties. They agree and disagree. If you talk about disagreement, they are not everywhere. So we have to really analyze themselves. Who are they? Categorize them. Maybe using whatever analysis that we have and try to making sure that every category of those landowners are attended. By using that, of course, we can solve or minimize some of the risks. That's why I did mention just now about land. Land matters. Very basic problem that we have wakaf land, Malay reserve land, Sungai Baru, Lisol, whatever. So by categorizing all those landowners based on their characteristic and demand and so on, we'll come up with fair and more adequate compensation. Bearing in mind that in this 486 Land Acquisition Act, there is no definition of adequate compensation at all. No, nothing. They leave it to the valuers to decide, and the valuers are having broad definition.
Why these questions?
Very wide definition.
Is that we are looking at 100%. If there is a group that is not agreeable and all that, I think there are avenues for them to come to.
Sorry, your stand is
100%.
There should be unanimous
Yes.
in order to have redevelopment. You do not agree to consent threshold 80%. How? Tell me more. How do you come to that?
Why we say that? Because at the end, there is a legal process in the event where, let's say, assuming the owner is untraceable, or the owner has passed away and all that, they can actually go to, there's a legal process where you can actually go to court, and then you can appoint the trustee to
and then the trustee must agree.
Yes,
therefore coming back to become unanimous.
That's right. Just to bring you to here, in this part of the world, we call it property management, property facility management, property maintenance and what, but actually in the US, they call it community living.
My opinion on the Kampung Baru is that we have to go back to the land matters, the problem of land, whether Sungai Baru is part of MAS or not. Why they ask the landowners to get out of their place while they have to wait for another days in terms of making decision from the court. So this is another. But in Pengerang, there are a lot of squatters in terms of Singaporean They are settling over there without any legal interest in Pengerang. And a lot of Malay reserve over there. Sorry, under section 3(1)(b), it has been amended by last Prime Minister. In 2007, they changed it to 3(1)(b) for the sake of economic development. It is not normal
That's rather wide.
provision of the...
So last question, Prof. Ismail, 100% or you allow a majority consent threshold for urban renewal? Your view?
We don't need all those elements or whatever because this act is enough. We just amend it.
Don't need URA. Just use that act.
Yeah, this is very powerful.
Wait. What if only 50% agree? Then you will still use that act and acquire the land.
Yes, but we have to amend it accordingly.